Saturday.
So how many? Just to manage our expectations.
About 5. About 5 for that would be great. We do it on the line. You don't want to drama, you just want to go to the issues. You know, because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Camino. He's our guide.
Okay, Your Honor.
Hello, Dr.
May I say good morning?
Good morning. Karibu.
So we have an opportunity. Then Aaron Dubi is also here. So
That is.
Aaron Dubi.
Oh.
Your Honor, let me be the first one to otherwise straightforward matter. Innocent unless and until he is proven guilty. So no amount of reasoning.
You will be slow on you.
Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel, it is factual. It is factual.
The right note.
Yes. When we
but
purport,
I'm sure Dr. Hamino is smiling at you.
when we purport,
I'm sure Dr. Hamino is smiling at you.
in fact, I'm one of the few who have the advantage of having interacted with you in the previous position in JSC. I know you have a very sharp mind. We don't need to come here and start. Previous position in JSC. I know you have a very sharp mind. We don't need to come here and start citing to you positions of law and affidavits. So I cannot, but any stretch of imagination, expect that a court.
I'm making a backup for the.
Yes.
We don't trust technology.
The technology.
I'm making a complete backup.
Yeah.
You can continue.
So I dare say, Your Honor, that
Sorry, Your Honor. I know the court warned us of decorum, but we plead. I am just 12 years in practice. We plead that Senior Macharia doesn't get personal.
There is a special reason, Mr. Njeru. I did what I did to your side. So that we remain focused.
with tremendous respect. What we have here is lawfare. which I urge you, Your Honor, to take judicial notice of, because we live in this country.
Very well.
I will repeat your honor.
How long more? I thought we were going to take 3 minutes. Now we are going to we sit here the whole day. Just off the cuff. How long more?
I'll tell you, sir. Just summarize this.
10 minutes. Continue, Mr.
Yes, sir. I will repeat
You
that
have 10 minutes.
we are submitting that once disclosure is done, the witnesses will be calling our officers from the first accused country. Those are disagreements. I'll go to the second limb, severity of the offense.
Three.
I'll go to the second compelling reason. On appraisal of the charge sheet, the amounts will appear casual.
The amounts will appear.
Minimum 1 million. But we believe Your Honor will win this case. And we'll draw your attention to section 62(1) of our second. 62(1) of our second. In the event we succeed, that provision is very punitive.
In the event,
We succeed.
we is
The
the
DPP
DPP.
prosecutes this case and we get a conviction.
Be successful.
Yes. We will be moving to section 62, subsection 1. And around that, the severity of corruption cases. For someone to interfere, we submit in the positive. Your Honor. Lastly, I've alluded, Your Honor, to what transpired yesterday. And I've said that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will occur. And we are apprehensive that in the interest of, in order to protect the integrity of the criminal justice processes, a plea bail report we agreed before this court and decide on this matter. That should be a minute.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail sentence should have done. Thank you.
How many of you
Please, I'll take the first one.
Because I listed, how many? Listed 11.
Yes,
And
yes.
one.
Not all of us, certainly.
So how many?
Uh,
Just to manage our expectations.
About five for that would be great. We do it on the line. We don't want drama, we just want to go to the issues. You know, because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Kaminwa. He's our guide.
I'm here, Your Honor. Yeah, may I say good morning?
Good morning. Karibu.
So we have a little then Aaron Dubi. Aaron Dubi is also here.
So that is.
Aaron Dubi.
Oh.
Your Honor, let me be the first one to just give
Allow
some.
me to record them.
So, Your Honor, let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point should be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning.
You disclose.
Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And sometimes, Your Honor, as a counsel, it is factual. It is factual.
The right note.
Yes. When we propose-
but I'm sure Dr. Hamino is smiling at you.
When we propose-
I'm sure Dr. Hamino is smiling at you.
In fact, I'm one of the few who have the advantage of having interacted with you in previous position in JSC. I know you have a very sharp mind. We don't need to come here and start the previous position in JSC. I know you have a very sharp mind. We don't need to come here and start citing to you positions of law and affidavits. So I cannot, by any stretch of imagination, expect that a court.
I'm making a backup for the.
Yes.
We don't trust technology.
The technology.
I'm making a complete backup of
Yeah.
the technology. You can continue.
So I dare say, Your Honor, that even the prosecution, because they're also lawyers, we all pass lawyers before we
Sorry, Honor. I know the court warned us of decorum, but we plead. I am just 12 years in practice. We plead that Senior Macharia doesn't get personal.
There is a special reason, Mr. Njeru. I did what I did to your side, so that we remain focused.
With tremendous respect, what we have here is lawfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today, and none of us can purport independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective. Your Honor, I'll make a confession to you. I was, and we shouldn't allow it. Your Honor,
Mr. Njeru,
I'll give the context. I'll give the context. I'll give the context, Your Honor.
the focus.
Yes, I'll give the context.
Focus here, Mr. Njeru.
The context. I'm not here to talk about where I was and
Sorry,
all
Your
that.
Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matter is that with respect, he cannot tell us from the back. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner, we understand. But let him get back to our case. Thank you.
Look at the affidavit.
A minute, Mr. Njeru. I complete reporting.
Your Honor,
Mr. Njeru, your brief response, you're responding?
they've made general averments. To start with, problem number one, they serve us in an affidavit this morning. We expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, the accused then the affidavit itself is marked with general averments. Not respondents agents, they are not naming which agents.
Oh, just to be clear, you responding to the objection or you continue with your submission?
I'm responding to
That
subject to
clear.
the averments, yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he respond to that, at least from the back. At the very least, that should be expected. He can't have a steak and eat it. The subject of these proceedings is the accused person. The rest of us are speaking here, and then we'll walk away. But this is the subject. That's the person you should focus on.
the issue on the table. Continue, Mr. Diego.
Much obliged, Your Honor. Now, including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. In custody for this kind of charges. Why? It can only be for, and it is that desire to continue punishing you that is driving the application for you to be denied bail. You cannot allow yourself to be used. I have consistently said that the last line of defense for this country, the only one remaining, Your Honor, is the judiciary. And let's not think. So regardless of what happens here with these protracted submissions and responses and counter-submissions, not fall under the trap of saying that you're going to write a ruling another day. In the meantime, he remains in custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court and he would have appeared. One of my colleagues here will speak about the facts, Ken Chesa, but I can tell you, Your Honor, the reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. I plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you.
You can continue, Mr. Njiro.
Your Honor, just to associate myself with the submissions made by Milimani Senior, drive the mischief. That the accused person is carrying.
Slower. Pause after every sentence.
Is charged before you with another person, Wafula Masungo, who is not before you. It is not that Wafula's whereabouts is not known. It's because, Your Honor, to perpetrate this mischief. In almost for explanation, Your Honor, Milimani Senior indicated that he was seeking summons. It's the same mischief, Your Honor. The opposition, Your Honor, was that you seek summons. Was not indicated to you. That is to say, Your Honor, must be read in light of that mischief. That other than pursuing other ulterior motives that are politically actuated.
Apologies. What's your direction? You directed?
Me, I'll bring you the direction.
Colleague is submitting on a fact unless he has evidence as to what he wants to speak about, we would ask him to take the rights of the accused person. Let's not impute ill motive to anybody unless they are willing to take the dog and ready to prison.
Is contained in the affidavit filed by the ODPP. That's not surprising, Your Honor, that the affidavit contains it has no tangible evidence that proves to the contrary. If I was to proceed, Your Honor, in response to the substantive application,
Must give direction on the objection. Belong to the law on bond and bail. Avoid instances which may persuade me to request for fact.
the affidavit contains mere speculations. There is no averment in the affidavit.
After every sentence,
Before you, the averments in the affidavits have no nexus with the charges before you. Neither the prosecution, nor the defense, nor the court are privy to. Would be tantamount or will amount to violating his constitutional rights. And most importantly, the right here. Witnesses are subordinates to the governor, the accused person. Again, is not contained anywhere in the affidavit. Has no probative value of whatsoever nature, and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more of case CH 046T it will not tell you is the registered owner of KAE 738F. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, as I pen off and invite my learned friends, to draw your attention to the charge sheet once again, that there is no charge where there is a charge of conflict of interests. At Article 50 in isolation of Article 25. In light again of Section 8 of the Magistrates Court Act. From Article 25. Has no probative value of whatsoever nature, and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more of KCH 046T, it will not tell you the registered owner of KAE 738F. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, as I pen off and invite my learned friends, to draw your attention to the charge sheet once again, that there is no charge where there is a charge of conflict of interests. At Article 50 in isolation of Article 25. In light again of Section 8 of the Magistrates Court Act. From Article 25, he tells you that the question if you look at the law, Black Laws Dictionary, Black Laws Dictionary, it will give you as to what is deemed to be compelling. No evidence produced. No law quoted. No case law. The integrity of the proceedings. Will not affect the so-called pending investigation of open society. I invite Mr. Njero to guide us on who next. Thank you, Your Honor.
Another
Willis, and then he says
You understand the implication, right?
We understand.
So you cannot submit the whole day and expect magic. We should be reasonable, and they say for a wise Chester, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue and Section 8 of the Magistrates Court Act gives the authority to or search warrants.
The Black Laws Dictionary, it will give you as to what is deemed to be compelling. Deemed to be compelling. No evidence produced. No law quoted. No case law. The integrity of the proceedings. Will not affect the so-called pending investigation open society. I invite Mr. Jero to guide us on who next. Thank you, Honor.
Another you understand the implication, right?
We understand.
So you cannot submit the whole day and expect magic. We should be reasonable, and they say for a wise Chester, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue and Section 8 of the Magistrates Court Act gives the authority to or search warrants. Not such warrants which they abused by literally and Nairobi bungling him into a police vehicle, bail, to deny bail. The High Court must provide cogent, the term that is cogent evidence, and he keeps referring to some ghost creatures called agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to the so-called agents. Was it Governor Natembeya's wife? Were they governors? And this must not listen to them. The accused person, Your Honor, civil servant. He is Natembeya County. He is a deputy at the time the so-called